Thank you for the invitation to speak at this virtual conference on the current challenges and difficulties in arbitration and how the courts can help in the interests of users and the appropriate relationship between arbitration and courts. Let me start by posing a question. Why do commercial parties choose arbitration? In a survey conducted by Queen Mary at the University of London and the law firm White & Case in 2018, they asked, what are the most valuable characteristics of international arbitration? The top 7 reasons that were given by those that responded in order of importance were enforceability of awards, avoiding specific legal systems and national courts, flexibility, ability of parties to select arbitrators, confidentiality and privacy, neutrality, and finality. The same survey asked, what are the worst characteristics of international arbitration? The answers included cost, lack of speed, lack of effective sanctions during the arbitral process, lack of power in relation to third parties, and national court intervention. Reflecting on these answers, I suggest that there are a number of ways in which the courts can help users of arbitration without being interventionist. The first is in relation to cost and delay. The courts can help embolden arbitrators to conduct arbitrations efficiently by rejecting subsequent challenges for lack of due process, where, for example, tribunals have, quite properly, fixed an expedited timetable, or chosen to decide preliminary issues, or summarily dismissed clearly unmeritorious claims. A second way in which the courts can help is to support the arbitral process, if requested, by making appropriate orders, such as preserving evidence or stopping the dissipation of assets. Thirdly, the courts should give the clearest message that guerrilla tactics by a recalcitrant party will not be tolerated. Courts should give teeth to peremptory orders made by tribunals. Do not allow satellite litigation to be used improperly to derail arbitration proceedings. Be very hesitant in issuing anti-arbitration injunctions. Fourthly, the courts can help users by reinforcing the finality of arbitration. This can be done by dealing robustly with challenges to awards, limit rights of appeal, give a strong and consistent message that awards will rarely be set aside. Fifthly, the courts can help users by being mindful of the first reason for choosing arbitration listed in the Queen Mary survey, enforceability of awards. This can be done by interpreting narrowly the grounds for resisting enforcement set out in the New York Convention, and do not allow public policy to be that unruly horse. Sixthly, the help that the court can provide is made less effective if its own proceedings take too long and cost too much. Also, consistency is important to users, and I recommend allocating cases to judges who are familiar with arbitration. Overall, the courts can help users by articulating and applying a pro-arbitration policy, a policy that respects the choice and autonomy of contractual parties. At the same time, the courts at the seat have a supervisory role and a role safeguarding the public interest. For example, by removing arbitrators that are not independent and impartial, and negating awards that are tainted by serious irregularity. But this should be done with constraint. So, to conclude, arbitration and the courts are not separate worlds. They share a similar procedural language. Both have the same role of providing a service to disputing parties. I very much welcome the opportunity to share views in fora such as this on the relationship between arbitration and the courts, and to share respective best practices. and I look forward to an ongoing dialogue. Thank you.